We are back on Taking Care of Business on Koerner Radio News Talk 1180, 1230 KGEO, and 1410 KERI. Our guest by phone, Rodger Bayne, Vice President of Group Benefit Services, Inc.
We were talking about taxes, Rodger. Can you go a little further on that?
Well, I think that the taxes that employers are going to feel are coming from a variety of different levels, but the most pertinent and the one that most employers are really concerned with today is what are my penalties going to be if I don't provide health care, or how do I avoid these penalties by providing health care, and where do they start? And the first thing I can tell you is please keep in mind, if you are an employer in America that employs less than 50 full-time equivalent employees, stop worrying about penalties and just worry about health care and the cost of providing benefits to your employees. There are no penalties. There is no employer responsibility for employers below 50 full-time equivalent employees. The challenge to that is remembering that a full-time equivalent isn't the same as what most of us think of today. So we now have to look at an employer that has 25 employees and a lot of part-time employees. And we have to calculate all of the part-time hours for everybody that's below 30 hours, add those hours together, divide them by 120 hours a month, and that result gives us a number of full-time equivalents. If those hours are great enough and you have enough part-times, then you could be 25 full-time employees, but enough part-timers to qualify you at that 50 size employer, which is now subject to the responsibility of providing affordable care to their employees or paying a penalty.
Well, the question becomes, is it beneficial to terminate your health care bill, your health care, and pay the penalties, or is it beneficial to keep paying the health care premiums, because I'm sure penalties are going to increase over time?
Well, that pay or play question is something that we're all grappling with. I think that most employers that are suggesting that they can scrap their health benefits and pay the penalty as a means to save money are going to find that they could do that today. And the reason they're not doing that today is because it is very difficult and challenging to hire, recruit, and train top talent and retain them in your firm without providing quality benefits. So the real question is, what happens to those groups that have been providing very solid quality benefits to their core staff and yet having a whole lot of tangential employees that are a little bit less full-time or viewed as less valuable or less skilled in their work, and they don't receive benefits? Suddenly now they're brought into the mix if they're full-time.
Well, I understand there'll be some issues regarding eligibility and discrimination that are going to play into this.
Well, there's certainly going to be eligibility and discrimination rules. The discrimination rules have been postponed a couple of times now as they drafted the law with a flaw using Section 105H non-discrimination rules, which are typically used in self-funded benefit plans, and PPACA makes them use those rules in fully insured, and they haven't quite figured out how to reconcile that. But pretty soon what it's going to mean is that if you have full-time employees, you're going to have to treat them all equally and not provide certain employees better benefits than others in a discriminatory fashion. We anticipate reverse discrimination favoring lower income employees with better benefits will be allowable and expressly allowable in the law. But beyond that, I think we have a big challenge.
What about premiums? Can you have different amounts for different classes or different groups?
I suspect that you're going to run afoul of the non-discrimination rules when you start classifying employees and paying contributions on different levels. And again, that's going to depend on their final ruling on how they translate the Section 105 regs into something that's applicable under PPACA. And we have not seen that final drafting yet.
Now, one of the rules that we have right now is it's really picking up and catching on more and more are health savings accounts. And I understand that they're going to be reducing the amount that you can fund in a health savings account and limiting the amount of the deductible that you can implement on your medical plan.
Well, in small group market, they're going to limiting the deductible of those qualified plans. However, there's possibility that a more astute health benefit exchange is going to recognize that a higher deductible combined with an employer contribution to the health savings account equates to a lower deductible, and that plan could qualify for sale in an exchange or outside the exchange. Determining that is going to be the challenge, again, in 51 different states and benefit exchanges, whether or not they understand the full ramifications of that. And from my experience, in dealing with the legislators and the regulators that are building these exchanges today, they really don't understand benefits and the values of the benefits in most cases, which creates a real challenge in trying to communicate this difference. So consumer-driven plans at large are going to be affected potentially very negatively by this and by the fact that the exchange claims in the small commercial markets that we cannot use higher than a $2,000 deductible, when many health savings accounts use higher than that today. I don't believe they're restricting yet the contributions to a health savings account any more restrictively than they are, so I think that's a good thing, but they are limiting FSA contributions under PPACA so that those benefits will be limited to $2,500 a year now.
Roger, it sounds like a nightmare. Our guest by phone, Rodger Bayne, Vice President of Group Benefit Sales, talking about Obamacare.
You know, Roger, one of the things that I recently learned was for you take someone who's going to be qualifying for Medicare, they're in their early 60s, ready to apply for Medicare, and they've been on a health savings account, that they will be penalized when they go into Medicare on their Part D because they have a non-qualified prescription drug program. Were you aware of that?
Well, yeah, if they have a non-creditable coverage for prescription drugs because they have a high deductible before their drug coverage kicks in, that's not on par with the level of benefits of prescription drug coverage under Medicare, so they say you cannot cover continuity. That's most affecting those that are late enrollees, those that join Medicare past their first eligibility date. So those that do, in fact, stay on employer plans or on a health savings account for a number of years and don't retire at their first opportunity could, in fact, pay a higher premium for that Medicare prescription drug coverage later on.
Now, see, I've had a couple of clients that are retired when they were eligible, and they're being penalized. So
I'd have to review that. I don't know that that's the intent of the case. I'd have to review that. I wouldn't say in stone that that's not accurate.
I've asked for a review on those already.
Right.
So what are we going to do, Roger? How are we going to fix this problem?
Well, I think you're going to see an increase in self-funded benefit plans in smaller and smaller groups as long as that is viable. And viable meaning the federal government and state governments are looking at that every day and looking at passing regulations which make it very unfair for small employers as compared to large employers, making it more difficult for them to use the same creative buying strategies and controlling their health care costs as large employers do. And self-funding gives them the opportunity to do that. They have more access to benefits information and claims information, and they know how to control and manage risk, just like they would for their workers' compensation. So that's going to be one direction as long as that's allowed. The next direction is just to continue to shout from the mountaintops about why we need this law to be changed and to be refined over time. I'm not optimistic that a full repeal is in the works or in order, but I am certainly convinced that we're not on a winning path right now with this law.
We're on a winning path?
We are not on a winning path. Absolutely convinced we are not on a winning path. We are not achieving enough of the core objectives, and the core objective would be access and affordability to care, and all we're achieving is access. And we're throwing money at it to make it feel affordable, but it's only affordable because we're throwing $2.6 trillion at it.
Well, here's my question. Currently, who does not have access?
Well, there is one problem where there are access. There is the working poor that are not eligible for Medicaid and simply cannot afford health insurance coverage. And in some states where they can't get health insurance, even if they wanted to, because of a medical condition. Now, my home state of Maryland, that's not been an issue in a long time. We've had guaranteed issue in all markets and a safety net in our Maryland health insurance plan for high-risk individuals that can't get it elsewhere. But as I understand it, many states have not established a successful ongoing high-risk pool to pick up those that don't have any other safety net. So in some states, an individual that has a significant medical condition simply can't get coverage, even if he had the money to pay for it.
But they can walk into any hospital anywhere and get treated.
Well, that is true. They can certainly get their emergency room coverage under the law and get treatment there in the most expensive place in the world to get health care.
Exactly. Roger, we're out of time. Thank you so much for the time. I really appreciate it.
My pleasure. Thank you very much.
Been a pleasure meeting you, and thank you, Roger.
Thank you.
We will see you again in 167 hours on Taking Care of Business on Koerner Radio News Talk 1180.